is something that if it occurs, the contract, after it's completed, it's executed, can be terminated or modified. So that would be like a warranty on an automobile or repair warranty or something like that. Now, this will not be a fill-in-the-blank question, and I'm not going to make you write out these different conditions or anything like that. I just want you to have an understanding of them because they're very, very important in contract law, like I said earlier. This is important for you in the real world because if you're doing a real estate transaction or you're going to buy a business from somebody that's retiring or whatever business you're in, you want to think through, what do I need to have happen in my own life to make sure that I can fulfill the contract? And so, if you're like, I had one here a while back where buying the house was conditioned upon the person receiving an inheritance from their grandparents. Their grandparents had passed away. They left money to the grandchild in their will. The will was in probate, so the money had not been released as of yet, because you have to have court approval. And so we did the real estate transaction conditioned upon the money having been released by a given date. And if it wasn't released by then the sellers could go find somebody else to sell it to. And it went through just fine. The court agreed to it, so it didn't be a problem. But you get the idea, okay? So if you're going to buy real estate or buy a business, you want to think through, what are the conditions that I need? I need to get a loan. I want to have it inspected. I want my lawyer to be able to look over the contract terms and the title. I want my accountant to verify the numbers. I want to look at tax returns and income statements on a business. Make sure there's no lawsuits. That whole process is called due diligence. You may have heard that term before. Especially in a commercial transaction, we want to make sure we have zoning, permit abilities, all that kind of stuff. And that period of time may take years, in a big commercial project. So that's where it's important that you work with your lawyer and your real estate to make sure that the contract has the terms that you need in it to be able to get out of it if you need to. All right. Again, back to voidable. So a voidable contract may be contingent upon a condition, and if that occurs, you can terminate the transaction. The last type of a voidable contract that I want to refer to is a contract that is not in writing, but must be in writing by law to be enforceable. Otherwise, it's voidable. So this brings us to another page. And that is page, let me find it here, page 75. Okay, list 4, 100%. Fill-in-the-blank question. And the reason why this is a very important page, because this is a list of the types of contracts that have to be in a written form or they're not enforceable by a court, unless the parties agree. So this comes from English common law, which was called the Statute of Frauds, the Law of Frauds. And this again goes back to English common law centuries and centuries ago. And this is the idea that there are certain types of contracts that are of such importance that there needs to be a written verification of the terms of the contract in order to be enforceable and to prevent fraud. What I mean by fraud is, maybe it's a real estate deal, and you're saying that I offered to sell you my farm for 20% of its value. And I'm saying, no, I didn't. And so you bring in 10 of your friends as witnesses who said, yeah, I heard the deal, and that's what Hasbrook agreed to. Well, they're all lying, right? So you're inducing them to fraud. That's a crime, of course, too. But I got no way to disprove that. It's 10 against 1. And so, because it was verbal. So the idea is, okay, in order to avoid fraud like that, there has to be a written agreement involving real estate. That's one of the categories where this applies. So let's just work our way through. Number 1 is a contract involving marriage. A nuptial contract. A nuptial agreement. So this, again, this goes back to Old English common law, when you had parents that would enter into a contract to marry their children when they hit a certain age, kind of like Game of Thrones, right? And the idea was that that type of a contract could be enforced by a court. In fact, a judge could order people to be married, a nuptial. And if a parent bailed on it, then they could be sued and the court could order them to be married. Now, we don't have that, obviously, anymore. But we still have the same idea when it comes to both pre- and post-marital agreements. So two people want to get married. Before they get married, they enter into a prenuptial agreement. That is an agreement that both spouses would enter into prior to their marriage, where they agree to keep some assets separate that were their own individually owned assets. They agree that their individually owned assets will stay with them if they end up getting divorced. And also they agree that if one or the other dies, their individual assets will go to their respective individual children or family or whoever they want. And they also agree they're going to commingle some assets, maybe a bank account and a house, and they agree that they'll split it equally if they get divorced. So that's a prenuptial agreement. So we do have that, and that has to be in writing, or a judge will not enforce it in a divorce case. And even then, there are some ways to get around it. Number two, a contract that, on the terms of the contract, will last more than a year. So I enter into a contract with you to mow my lawn every month for 2 years, and I'll pay you $100 each month every time you mow it. You're like, ooh, that's a pretty good deal, $100. You can see my lawn. It's big. But I live out in the sticks, so, and it's bumpy. So long story short, that's a 2-year contract. So we get a few months in, and you quit doing it, so I sue you. You say, well, no, it wasn't in writing. That's a 2-year contract. Yeah, I owe you the money for what mowing you did, but it's basically voidable. Number three, we've already talked about real estate. Any contract involving real estate has to be in writing. And this does occur where people, maybe I'm having an open house, I'm selling my house by owner, and people are coming through and somebody comes in and says, oh, I love your house, I agree to buy it, and we verbally agree to all the terms, but it's not in writing. And then the next day I sell it to somebody else, so you sue me. Like, nope, not in writing. All right, number four, an executor's promise. I don't have that one highlighted because this is not super common, but this is where an executor is the person that's in charge after a person dies of handling their estate, to follow through the terms of their will, to pay off debt and creditors, and to distribute the assets to the people named in the will. So if an executor is not liable for the debt of the deceased person from their own assets. So if my brother dies and he has thousands of dollars in credit card debt, and I'm his executor of his estate, I am not personally responsible for his credit card debt. I'm not on that account. I'm just handling his estate. And if he doesn't have enough money to pay the credit card, too bad for them. They can't go after me personally unless I agree to pay that debt on my brother's behalf in writing. That's a form of a cosigner, which is the bottom one. So in order to be liable on a dead person's debt, if you're handling their estate, you must personally, in writing, agree to it. And that's not super common. Number five is very common. And this is one where we have a dollar amount. In some states it's $500. In some states like Oregon it's $750. Some states it's $1,000. This is a contract for an agreement to sell goods in the future, not simultaneously, in excess of $750. So let's say, for example, I'm having a garage sale, and you come to my garage sale, and I have a mountain bike. It's a dual suspension made out of titanium. It's probably $5,000 brand new. I mean, this is a nice bike. I don't really have one, but let's say I did. And so you come, and I've got a price tag on there of $1,000. You're like, that's a great deal. So you say, Hasbrook, I'm going to go to the bank right now. I'm going to buy your bicycle. I'm going to get the cash. I'll be back in 10 minutes. I'm like, cool, we have a deal. So you go off to the bank. Somebody else comes along. They have $1,000 in cash. They give me the cash. I give them the bike. And they ride off into the sunset. You show up a few minutes later with the cash. You're like, where's the bicycle? I'm like, well, I sold it. You know, cash talks. But we had a deal. Well, it was not in writing. Therefore, it's not enforceable. So it may kind of seem like I'm being lame there, right? I mean, I said I'd sell it to you, but it works both ways. What if you agree to buy my bicycle for $1,000, but you never come back from the bank, and I turn away 3 other people? So it protects both sides. That's the idea of this rule. I call it the garage sale or the Craigslist rule, because that's where you see it a lot. Again, future. So if you give me $1,000 and I give you the bike right there, this doesn't apply. That does not have to be in writing. However, you should always get a bill of sale if you're buying a used good, like on Craigslist. Make sure what I do, I bought an outboard motor for my boat once on Craigslist, and I had the seller right on there, I am the true and lawful owner of this motor, serial number, and I represent and warrant that I can sell it and nobody else has any right, it's not stolen, yada, yada, yada. And I had him sign that. That way, if it turns out the motor was stolen, I could say, I bought it in good faith. So it's always a good idea to do that. And then finally, number 6 is the cosigner rule. And again, we're talking about contracts that have to be in writing, or they are voidable. So the cosigner rule basically is a rule that in order to be responsible for somebody else's debt, you're not the original debtor. In order to hold me responsible for that as a co-debtor or a guarantor on the debt, that has to be in writing. So if my son wants to go buy a car, and let's say he doesn't have very good credit, so I agree to go ahead and co-sign on the loan. If he doesn't make payments on the car, and they want to go after me now for payments, my agreement to pay his debt would have to be in writing. Otherwise, that's not enforceable. I actually had that happen once. The son operated a commercial vinyl printing business. So this is like the vinyl you see on the side of semi-truck trailers, like Safeway and whatnot. You know, they have all the bananas and stuff. And so they had this printer that was, I think, if I remember, it could go up to 15 feet wide and up to 100 feet long or something like that. It was a thermal printer. It was like a $300,000 piece of equipment. It was expensive. This was years ago. And so the son bought it on payments, but didn't have all that good a credit, so they were going to require the dad to co-sign. And he agreed that he would. So they wrote up all the contracts, and they forgot to include the cosigner agreement in all the paperwork. I mean, it was about 1.5 inches of paperwork. And so, of course, what happens, the son defaults, they go repossess the printer, they sell it at auction for like $20,000. So he still owes 100 and something odd thousand on it, and they went after dad. And so I wrote him a letter as part of discovery. They sued him. Like, okay, show me the written guarantee. Didn't happen, so they had to dismiss the case. So that's where that type of thing applies. All right, so list 4 types of contracts that have to be in writing. That would be my type of a test question under the statute of frauds. All right, so we are going to break there today because I'm almost out of time and I don't want to start another segment with only a few minutes left. So have a good weekend. Try to stay dry. It's going to be rainy, wet. Although we need the rain.